Hello, friends. Welcome, welcome. I'm Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Well, we have a year-long special series on what else? The EB-5 Reform and Integrity Act of 2022, RIA or RIA. Today, we're going to cover what I'm calling the state of play. What's going on in the current landscape, in our environment of many questions, some answered, not to our liking, and others big questions yet to be determined. And to me, this week sort of feels like a week of relative calm. We still have those questions hanging above us, but there haven't been, this popping up of events that sort of shake things up. Feels very much like the calm before the storm. And certainly one of the shoes that could drop is the outcome of the litigation against USCIS, first brought by Bering Regional Center and a second suit brought in the District Court of Washington, D.C. By a number of regional centers, IIUSA members, initially spearheaded by IIUSA. The Bering litigation is before the Northern District in California. So let's just hop right to it. And I thought we would also try to cover one of the major questions that really do need some clarity on, and that relates to how the set-asides are ultimately going to be interpreted and implemented by both the U.S. State Department and USCIS. So now let's jump. So litigation, what's going on? Well, we had the hearing before Judge Vince Chabria on June 2nd, where to me, and I think most of us observing the proceedings will agree, it seemed like the judge was positioning himself to find in favor of the plaintiffs, that is, in reversing the service's position that regional center designation must be filed and approved under RIA, the form I-956, before regional centers can recommence operations and begin fundraising with new investors under RIA. Now, the question there with which that hearing ended, it was a bit of a cliffhanger, is if the judge does in fact find for the plaintiff, what is the scope of the remedy? Will it be limited to Bering Regional Center, or would it apply more broadly in favor of regional centers across the board, across the industry? And to that question, IIUSA, Invest in USA, the EB-5 Trade Association, filed a motion to intervene on June 6th, where IIUSA requested that broader remedy should the judge find in favor of regional centers and against the service's interpretation of the RIA in this respect, to apply that remedy more broadly across all of the regional centers, not limited to just the plaintiff in this instance. And a hearing on this motion is set for July 14th. Now, of course, I'm getting questions from all over the world. When are we expected to hear from the judge? When are we going to get some resolution to this issue of whether or not regional centers can go out now, or whether got to wait until 956s are approved first? And although some have thought that we would get an answer to this earlier than today, some were predicting, some close to the litigation, the Monday following the hearing. I do rather think that we'll be waiting until at least the hearing on July 14th, where the judge will hear arguments in favor of broader relief. And I think that's really going to be a momentous decision. And I don't think we will have meaningful resolution to this litigation before then. That's just my opinion. So we'll all be listening very, very closely to what happens at that hearing. And of course, the parallel litigation before the district court in DC is ongoing as well. And in that litigation, it's already set up to request broader industry-wide relief. So that's sort of, we have that as well in case there's a narrower holding on the bearing case forms. So we're seeing a proliferation, if that's the word, of new forms from USCIS implementing RIA. The first we saw, of course, was the 956, where regional centers are filing to seek redesignation or designation under the RIA. With that came the 956H, which is the form that persons involved with regional centers must complete to show that the principal meets the bona fides requirements of RIA. We recently saw the new form I-956F, paragraph F, key to subparagraph F of the amended INA 203B5 that discusses the new exemplar requirements. The exemplar form is what we used to call these project pre-approvals that were filed previously under on the form I-924. Now they will be filed under the form I-956F. And right now, under the current USCIS interpretation, the 956s must first be decided before regional centers can file the 956F, and the receipt of which will need to be in place before investors' I-526s can begin to be filed for that specific investment project. If the litigants prevail on the litigation against USCIS, then the regional centers will not need to await 956 approval, or indeed they will not need to file the 956 in the first instance. Instead, though, they will still need to file the I-956F and have that receipt in hand before filing associated investor petitions. So that's what's going on. One additional form has come down from USCIS, which is the I-956G. This is the successor to the prior I-924A, the annual regional center certification filing. And both of these forms are quite different from their predecessors. And so we'll likely be discussing them in greater depth in future webcasts. So let's touch on set-asides. My goodness. So this is, of course, a huge change brought by the Reform and Integrity Act. Now we have these subcategories beyond simply TEAs and non-TEAs. We have these subcategories or set-asides with separate visa queues. In total, the set-asides will occupy 32% of the annual allocation of EB-5 investor visas. And the 32% is split along three different set-aside categories. 20% of the 32 allocated to rural area projects, 10% of the 32 to high unemployment area projects, and 2% to the brand new infrastructure category. So, and one of the main questions here has been, who will benefit from the set-asides? Will the set-aside allocation go to investors already in queue? And investors who have already invested and are waiting for visa availability, or will they only apply to investors filing after enactment of RIA? And we have some movement here that I want to share with you. So let's just do a little share screen, shall we? Let's do that. Okay, so what we have is recent liaison minutes from a meeting that the State Department held with the American Immigration Lawyers Association. And a shout out to AILA for doing the phenomenal work that it does on behalf of investors, on behalf of immigrants and their representatives, attorneys, the bar. And for hosting these liaison meetings with immigration agencies, including the State Department. And kudos to the State Department for having these liaison meetings and sharing information about processing and interpretation. So thank you to both. So this is public on the State Department website. And when you click that link, you will see about 25 pages of minutes summarizing the last liaison meeting held between AILA and the State Department. And for our purposes, we're right here, starting page 4, where there are 3 or 4 questions answered specific to RIA interpretation and implementation, okay? And they start here with item 10, EB-5 RIA implementation. And I'm just gonna read the questions and go over the answers and just try to unpack what's going on here a little bit. So the first question is, has DOS, Department of State, liaised with USCIS regarding the visa set-asides for rural high unemployment and infrastructure projects established by the EB-5 Reform and Integrity Act of 2022, RIA? If so, how will these visas be allocated? And this speaks to how the numbers are allocated in our immigration system. And of course, we know, thank you, State Department and Charlie Oppenheim, in sharing this process with us over these years. The process of allocating the annual limits, the visa numbers, falls with the State Department Visa Office. And so it is a joint enterprise in terms of how the numbers are allocated and how the petitions are classified for sub-allocation within the 5th preference category, the EB-5 visa category. By way of quick backdrop, we have a little over 7% of the annual worldwide limit of employment-based visas. So that gives us a little under 10,000 annually in EB-5. And within the annual allocation, we now have that 32% carve out along the set-aside subcategories. So let's drill down here to the response. DOS continues to liaise with USCIS on the implementation of the EB-5 Reform and Integrity Act of 2022. The set-aside categories will be allocated as outlined by the RIA. Not very helpful there, because that's what we assume. The question, of course, is more about the nitty-gritty. How are you going to allocate these visas? When will DOS and USCIS publish joint guidelines, a bit of an assumption there, on the visa set-asides created by the RIA? Will DOS add notes to the visa bulletin to provide guidance on the new set-asides? Response: as noted above, DOS continues to liaise with USCIS on implementation of the RIA. The visa bulletin describes the new set-asides, and this is what the State Department means. So this is the visa bulletin for July 2022. If you haven't bookmarked it, do. This is important, a lot of information here. And this is what the State Department is talking about. This is all of employment-based. We're right here in 5th. And these are the new RIA categories. We have unreserved, which is everybody except the set-asides, okay? And then the set-asides are here. Fifth set-aside, rural 20%, high unemployment 10%, infrastructure 2%. Okay, and these are the traditional subcategories within EB-5. C5 is direct outside TEAs. T5 is direct in TEAs. R5 is regional centers outside TEAs, and I5 is regional centers in TEAs. So I5 is where the vast majority of petitions in the last 10 years have been. Question 11, what process will state and USCIS adopt moving forward on newly filed cases to clearly designate I-526 petitions that fall into set-aside categories so that state can clearly distinguish which petitions receive the set-asides? Response, new EB-5 visa categories were established to distinguish between the various set-aside categories, as well as whether the 526 petition is for regional center project or non-regional center project. Okay, not very helpful there. So they're just saying that there are new visa categories created. Just hold on. What process will state and NBC and USCIS adopt moving forward on approved I-526 petitions to clearly designate I-526 petitions that fall into one of the set-aside categories so that state can process them in accordance with the reserved visa set-asides for rural, high unemployment, and infrastructure categories? So you can see here, there's an attempt to drill down and get more concrete response here. Response, state cannot speak to the petition approval process and designation by USCIS, but state will process the application per the approved EB-5 visa category. So what's suggested here is that state is going to follow a mechanical process, and it will allocate the numbers according to the set-aside formula by the way that they are classified by USCIS. They're going to treat them as they get them from USCIS with the classifications affixed to those approved cases. 12. Have USCIS and state worked out a process to identify pending or approved petitions that may qualify for reclassification or petition portability under the RIA's new reserved visa set-aside rule? So this is saying, are you going to apply the set-asides to pre-RIA cases, whether pending or approved? For example, if there is a Chinese national with a pending or approved I-526 petition filed under the fifth preference unreserved I-5 and R5 category with a backlogged January 2017 filing date now seeking reclassification under the identical EB-5 preference set-aside, rural 20% category, do state and USCIS plan to allow upgrades or reclassification of a prior rural-based unreserved regional center case to a rural-based reserved set-aside? This needs to be done in accord with the OS's general policy to give priority to those petitions that have already been filed, particularly when the definition of rural under the prior statute is identical to that under the RIA. So this is a good question because it's pressing state to ask, really at its heart, if you're not applying the set-asides, if you're not allocating set-asides to pre-RIA cases, is there a basis for that? Because the rural definition is the same pre-RIA and post-RIA. So no one needs to re-adjudicate whether or not that petition is a petition based on investment in a rural area. Response, pending petitions filed prior to the enactment of the EB-5 RIA will be adjudicated under the law in effect at the time of filing. Petitions approved prior to the enactment of RIA will retain the classification set by USCIS at the time of approval. So this is where we are with our question. Not to say that it's completely firm and settled and clear, but this is a statement of State Department thinking on the question of who gets the set-asides. And it is new cases filed post-RIA. Pending petitions, cases filed pre-RIA, are going to be decided under the framework in place pre-RIA, that is to say, pre-set-asides. And the classifications given to approved cases, so read in parentheses, even rural cases that share the same post-RIA definition, will keep the prior classification under the pre-RIA regime. Now, let's come back to this. This is the important question and answer, okay? 13. Before the recent congressional reauthorization of the EB-5 Regional Center program, AILA members reported being told that the NVC, the National Visa Center, had no way of distinguishing between EB-5 Regional Center and non-regional center cases, and as a result was not sending any EB-5 cases to post for adjudication. What effort is state taking to ensure that these categories are separately reportable in its systems? We saw that they are. They have different categories, C5, T5 versus R5 and I5. Response, NVC is able to distinguish between regional center and non-regional center applications and continue to process non-regional center applications during the lapse in the former regional center program. Since the passage of the RIA, new EB-5 visa categories were established in order to track all EB-5 categories throughout the application life cycle. Okay. Are there plans to classify EB-5 cases that were already approved and are pending at the NVC and consular post? This is a permutation of the prior question. Response, as stated above, petitions approved prior to the enactment of RIA will retain the classification set by USCIS at the time of approval. Can state confirm whether NVC is sending both types of EB-5 cases, regional center and non-regional center, to post for adjudication and interview? Yes, NVC is processing all EB-5 cases that were grandfathered in by the Reform and Integrity Act. So all of the regional center-based cases as well, with immediate visa availability, are continuing to be sent to interview. They're continuing before that point to be processed by the National Visa Center until they're documentarily complete. So that's good news. At least that's the position. Whether or not it's working well, separate questions. So let's go back here to B, because this is really an aspect of this important conversation. Petitions approved prior to the enactment of RIA will retain the classification set by USCIS at the time of approval. Now, I will posit that there is some room here and here to create the space for visa allocation, set-aside allocation to pre-RIA cases. And one sort of a technical kind of a superficial perhaps sort of way, and but a more meaningful way. So the classification set by USCIS, classification TEA versus non-TEA. And we have, TEAs are both rural and high unemployment. So we know that pre-RIA cases were classified by TEA and non-TEA, and in the same defined way. They were rural and high unemployment. And indeed, we have the same TEA categories, classifications in the post-RIA world. So perhaps there is no real firm shutting of the door to applying or allocating the set-asides to pre-RIA cases. Why is this important? Well, it's important because we certainly want to avoid wasting numbers. These numbers are precious because we have oversubscription, we have more demand, we have more investors who have invested, whose money is working, then we have visas. So when we have availability, we want to optimize that usage. We don't want a single precious visa to go unused in our category. We have a lot of EB-5 visas this year. We do across employment-based generally because of COVID-related underuse on the family-based side. And this is 2 fiscal years in a row that this has happened. Because the consulates were not operating at pre-COVID levels, lots of unused family-based members flowing over onto the employment-based side. And we have double, essentially, the number of employment-based visas that we have in normal years, and double EB-5 numbers. And so that means rather than merely 3,200 or so visas in the set-aside categories, we have about 6,400. So that's good, but if they're not going to be used, that's bad. Now, by operation of RIA, these set-aside numbers will roll over and stay in EB-5 and stay in the set-aside subcategories for 1 additional fiscal year, fiscal 2023 to the end of September 2023. So, and then the set-asides will also refresh. We'll get another 3,200. So we could, depending on how quickly the State Department and USCIS have visa interviews and adjudicate adjustment of status applications, we are probably going to have a lot of EB-5 visa numbers in the set-aside subcategories all of fiscal 2023. And we've got to use them. And the post-RIA petitions, except perhaps the cases eligible for adjustment of status, will not be able to take advantage of these numbers because they've got to wait until the 526 petitions are approved, and then they've got to wait until NVC checks through the documents and gets them documentarily complete before an interview can be scheduled at post. And so a lot of this, there is a lot of pressure on the agencies to chunk through these applications. And we know that USCIS is struggling under the weight of a tremendous backlog. So there is a burden on the agencies to move through these applications so that we can optimize visas usage. And so that's operational, but we can also do this, I believe and hope, by policy and perhaps by statutory fix, to be able to use these numbers when they're available to avoid losing them forever. Once these visa set-asides have rolled over once, they won't roll over again if they're unused. They'll be judged through the INA, the Immigration Nationality Act, which calls for unused EB-5 going up, back up, flowing up or falling up to the EB-1 category, and they won't flow back down to EB-5, so they'll be lost to EB-5 forever. So one policy fix is adopting policy and interpretation to permit using these numbers in a smart, optimal way, so that if there are post-RIA cases that are available, that are eligible for numbers issuance, by all means, absolutely take them down, take those numbers down and apply them to the new cases. But allow the pending and approved cases also to be allocated a visa. Certainly there are existing principles. The whole concept of having priority dates is about identifying the place in the visa queue by petition filing order. So, and the USCIS also has a policy that recognizes this, which is the visa availability approach, adjudicating 526 petitions with immediate visa availability ahead of petitions filed by nationals in the backlogged countries, so that we can optimize visas usage. So there are precedents, operational principles. I would even argue, certainly the language of RIA does not preclude that interpretation. So this is a call for the agencies and advocates and stakeholders to encourage State Department and USCIS to be practical so that we can optimize, as I keep saying, usage of these very, very precious numbers. I feel like I've said enough. So, and I do see a few questions, so I think I'm going to take a couple before saying toodaloo for the day. How are you advising NCEs to comply with this when creating policies and procedures? Each new commercial enterprise shall deposit and maintain a capital investment of each alien in a separate account, including amounts held. So this goes to subparagraph Q, the new fund administration provision, and this is outside the scope of what we're talking about today. Fund administration provisions are new, and they have their complications as well. There are waivers and exceptions and special treatment for affiliated JCEs, job creating enterprises. So I'm going to hold off on that, but invite you to come and attend a future webcast where we'll probably cover this important new RIA development. All right, Carolyn, we heard from Judge Chabria in the Bering case, who said that he had hoped to provide a decision sooner on the PI motion. The delay, preliminary injunction motion, the delay in his decision results from the fact that his entire staff came down with COVID. Oh my, sorry to hear that. We do hope to hear in that case prior to the 7/14 hearing date. Oh, well, thank you so much. Thank you, Lulu. That is very informative. So we might hear from the judge on the Bering case as to whether the scope of remedy is limited to, first of all, what the remedy is, and whether it's just limited to the litigant there or not. Just letting you know, not necessarily. Okay, so we don't know when this ruling might come. Let's just be clear about that. It might be that it's before July 14, but it may not be. So this is, we don't know. We just don't know. And of course, you know, so much hangs on this, because if it turns out that we don't need to wait for the 956s to be approved or even to be filed, then it's going to be all about the 956Fs and the receipts. And at least in that sense, there'll be a level playing field on those, because I think we can be pretty well assured that regional centers with live projects have their 956Fs ready to go and to be FedEx boxes sealed so that they can be dropped as soon as we have an answer to this, so that they can get the 956F receipts as soon as possible, so that their investor 526 petitions can be filed. So this can be that if that happens, that will certainly create a high energy environment in the entire EB-5 ecosystem. Okay, so thank you for joining me as always. I will send links to the AILA State Department Liaison minutes to those of you who registered for the webcast. They're publicly available. You can Google them and find them. And stay in touch, stay in tune, and we'll be talking again very soon. Be well.